We continue our discussion on abortion cases at the Supreme Court now with our next guests. But first, let's recap the two historic pro-life cases the Supreme Court dismissed. The 9 justices unanimously rejected FDA versus Alliance for Hippocratic Medicine, a lawsuit that challenged the Food and Drug Administration's safety measures on the abortion pill mifepristone. As a result, the drug remains available to patients without an in-person doctor's visit and can be received through the mail. The High Court also dismissed Idaho and Moyle versus United States, leaving in place an order by a federal judge in Idaho that blocks the state from enforcing its abortion ban. This means Idaho hospitals receiving Medicaid funding must allow abortions to be committed in emergency rooms. For more analysis on these cases, Steve Aden, Chief Legal Officer and General Counsel at Americans United for Life, and Sarah Parshall Perry, Senior Legal Fellow at the Heritage Foundation. Thank you so much for joining us. This was indeed a consequential Supreme Court term, one that didn't have the kind of splash that we had 2 years ago with the overturning of Roe versus Wade. Steve, what are your impressions of the Supreme Court's abortion cases this round?
Well, both these cases had one key thing in common, and that is both were resounding victories for the rights of conscience of pro-life doctors and nurses. In the Alliance for Hippocratic Medicine case, although the court did unanimously say, look, you don't have a legal right to come in and challenge the approval of RU46 chemical abortion, that case will go forward with 3 states, Idaho, Missouri, and Kansas, continuing to litigate it. And the court also said quite a lot about the rights, the federal rights protected under law of pro-life doctors and nurses. And the main thing they said was that although you as pro-life doctors can't challenge this law, it remains true that you can't be forced to provide chemical abortion. And that's a key finding. They can't be forced to provide it. They can't be forced to participate in any way, shape, or form. In fact, the Alliance for Hippocratic Medicine case, I think, was the most resounding victory in its language for the healthcare rights of conscience of our pro-life doctors and nurses that I've seen probably ever from the Supreme Court. In the EMTALA case, similarly, the court said, look, you can't force pro-life ER personnel to do abortions. That also is a very strong holding, and one that pro-life doctors and nurses, I'm sure, will take to the bank as they defend the right to life in this country.
And as those other cases that you mentioned make their way up through the courts, Sarah, did you have the same impression of the end of the term?
Yes, I did. And it's important to note that these were 2 procedural outcomes. So in the instance of Alliance for Hippocratic Medicine versus FDA, as Steve said, this was simply a holding that the doctors and the physician organization lacked a cognizable interest that they could trace directly to the FDA's actions in 2016 and subsequently in 2020. That was ultimately simply a disposition on whether or not those individual plaintiffs had a claim against the FDA. But as Steve noted, it's important to recognize that the litigation will now go forward on behalf of states who are representing those claims against their citizens, well within their right to do so. In the EMTALA case, this was a case about federal preemption. And what the Supreme Court did was issue a dig order, dismissed as improvidently granted. And Justice Barrett's rationale was simply that the rationale of both parties, their arguments, their concessions had changed at the appellate level, and the emergency positioning of the state of Idaho was not appropriate in this case, so the underlying litigation will continue. This was simply a temporary victory for the Biden administration, but no doctors will be forced to violate their conscience rights when they are in an emergency room faced with a situation that requires an abortion to be performed.
Those were certainly wins that didn't carry into the mainstream media. Stephen, let's play a game here on hypotheticals. While the pro-life movement was disappointed in the mifepristone case loss, what kind of case would have been successful? What kind of case should pro-lifers be looking at bringing?
Well, I think you're looking at the case that the states are bringing now. If the case is continuing, and a successful case will have those states win on their charge that the Food and Drug Administration acted illegally and without regard to women's safety in approving chemical abortion. That's what the trial judge said, Matthew Kaczmarek, and he set aside the entirety of chemical abortion's approval. The Fifth Circuit Court of Appeals went halfway and said, well, we can't go back and challenge the original approval, but these rules that you've issued, loosening the availability of chemical abortion, for example, allowing it to be sent by mail, not requiring that it be dispensed in person, not requiring that abortionists report the consequences of taking chemical abortion. Those things you can challenge. And so a victory by the states could be the whole thing. They could demonstrate, and I think they have a very strong ground for doing so, that the Food and Drug Administration acted outside of its authority and against women's safety by approving chemical abortion as safe and effective.
Now, Sarah, Steve just used one of the big buzzwords of the term authority. Did overturning Chevron, that case about the fishermen and the regulations out of government agencies, it wasn't about abortion, but it did change government agency power. Did that give an opportunity to slow down this aggressive pro-abortion agency mandate that usually come out from Democrat administrations?
Absolutely. In fact, we saw the rule that was forcing Veterans Administration hospitals to become essentially voluntary abortion clinics. That was the final rule on abortion that the administration issued. Now that Chevron's overturned, rules of that nature are going to be essentially straight in the crosshairs. We now have the opportunity to challenge things that the administration has done and for which they have essentially exploited what they perceive to be any ambiguity in the law. But the Supreme Court was very clear. It is our duty to enforce the law and to say what the law is. That dates back to Marbury versus Madison in 1803. That is going to make a significant impact on this administration and on the use of the administration going forward. Whether that's Republican or Democrat in the White House, the administrative state, as we all know, has grown too big. The bureaucracy is too large. It is too impactful. And we've seen multiple times those particular administration rules struck down. I think this was the final death knell for the growth of the administrative state, and it puts the power back in the hands of the people and their elected representatives to enforce and enact laws that are representative of the wishes of their constituents.
Well, it certainly is a motivator for those who are considering not showing up at the ballot box to really come out in droves. Stephen, what is the Supreme Court then set to review next term related to abortion? What should we be looking out for?
Well, I want to say this case actually involving transgender surgery could be critical. One of the questions that the Supreme Court left open in the Dobbs case, which overturned Roe versus Wade, was, is there any longer a requirement, as the court had previously said under Roe, that if a minor wanted an abortion, a state had to give her a legal mechanism to get one, to go through the courts? Without parents' knowledge or consent. Is that rule still effective after Dobbs? We don't think so. And that's really the critical question in this case the Supreme Court will consider next term, whether it's transgender surgery or whether it's abortion on minors. Can parents be cut out of the loop? We don't think so. We think that parents actually have a constitutional right as parents to participate in their children's medical care. And we do believe the court will say so this coming term.
Sarah, are there any cases that you're watching in particular, any at the state Supreme Courts?
I think definitely we're going to see some challenges on a continuing basis to some of these ballot referenda that have been instituted after they've shown up in the ballot box. We've seen an increasing attempt by state legislatures to push through these state constitutional amendments. But it's important to note that constitutional amendments are specifically a relation to govern government. That's what constitutions are for, whereas bills, legislatures, laws are a way to govern people. So it's an encouragement to those individuals who may not have been sort of in anticipation of the election to go out and vote when there are state referenda on the particular dais. But these are very much going to be, I think, front and center during this election. We're going to see ongoing challenges to the interpretation of state constitutional law. We've moved away from the federal constitution after Dobbs, but now we're looking at state constitutions and what the definition of life or privacy or fundamental right is in those states. We've already seen a number of challenges, and I think those are going to be ongoing.
Absolutely. Well, we'll keep watching those. Thank you so much for your time.
Thank you.